With only 5 days left in the Alec Baldwin trial, lawtubers must put away their streaming equipment because the trial is over. The judge in Baldwin's involuntary manslaughter trial has granted the defense team's motion to dismiss the case, and this story is crazy. So sit up, listen up, and then let's break down this situation. As we all know, Alec Baldwin was charged with involuntary manslaughter after the on-set shooting of cinematographer Halyna Hutchins, and it has been a turbulent process. Baldwin was originally charged in early 2023, and then those charges were dropped, and then he was recharged almost a year later with the same charges, a topic that I have already covered, so make sure you check it out for a deeper breakdown in that video. Let's fast forward to 5 days ago with the start of this trial. Baldwin's well-paid defense team filed motion after motion to dismiss the case, citing misconduct during the grand jury process, that the gun was damaged during forensic testing, and that the prosecutors had improperly handled the evidence, and more. And those early motions were not granted. But eventually, the motion that resulted in dismissal, the one that hit its mark, the one that wasn't firing blanks, okay, that's enough, you get it. The one that hit the bullseye was filed last Friday, and the allegations in it were wild. The successful motion to dismiss was really only 4 pages long, and it told a riveting but seemingly impossible story. Here are the highlights. The Santa Fe Sheriff's Office and the state have concealed from Baldwin that there was evidence that the live round came from Seth Kinney, a supplier of ammunition to the Rust set. Immediately after the Gutierrez-Reed trial, Troy Teske, retired police officer and judge pro tempore in Mojave County, Arizona, delivered a collection of live ammunition to the Santa Fe Sheriff's Office. The motion then goes on to explain why defense believes Special Prosecutor Morrissey has known about the source of the ammunition since November of 2021 after an interview with Troy Teske. They say Teske delivered the collection of rounds to the CST Popple, where it was taken into custody of the state by Popple and her supervisor, Lieutenant Brian Brandel. The evidence, however, was not inventoried to the Rust case. Instead, Popple was told to log it as documented information rather than physical evidence. And she was told to log it under a different case file so that it would never be disclosed to the defense. Among the rounds that SFSO took into its inventory and logged under a different case number are Starline brass castings with nickel primers matching the live bullet that killed Hutchins. So, with this information, the defense is telling the judge that the prosecution was aware of the possibility, even the likelihood, that this ammunition would exonerate Baldwin, and they purposely hid it. And if you don't believe my words on this statement, here are theirs. To support its theory that Baldwin should have known of that risk, the state is attempting to establish a link between Baldwin and the source of the live ammunition. The only way that it can do that is by demonstrating that the live rounds were brought to the set by the movie's armorer, given the state's assertion that Baldwin should have been aware of her youth and inexperience, and therefore the possibility that she brought live rounds to the set. Evidence that the live rounds came from Kinney is therefore favorable to Baldwin, which is why the state buried it. Wow, those are big words. So the defense filed this motion under Brady, Giglio, and Rule 5-501 of the NMRA. These two cases and this codified rule set out the requirements for prosecutors to divulge exculpatory evidence. Of course, exculpatory evidence is that which tends to cast doubt on the guilt of the defendant in one way or another, or to otherwise show that the defendant might not be guilty, either factually or legally. In sum, if the prosecution has evidence that would help a defendant, they have to give it to his lawyers. Full stop. They can't hide the ball. And this is different than the rules that govern civil discovery. Because in a civil case, generally speaking, lawyers don't just hand over evidence unless and until the other party asks for it. And even then, some lawyers are like, knuckleheads. That may not be helpful in the pursuit of truth, but civil cases are supposed to be the meeting of equal advocates in a neutral zone, the courtroom, and it's not really like your opponent's job to help you. But this is not so in criminal cases, because although the prosecutor is an advocate for the state, for the people, the state also has so much power through the prosecutor that the rules require the prosecutor to kind of play both sides. Not pure advocacy, but the actual pursuit of the actual truth. What you and I would call justice. It's a high bar. It's not like being a regular lawyer or even a YouTube lawyer. Because due process, like actual justice, and sometimes even life and death but definitely freedom. These hang in the balance for defendants. And so, no, you can't hide evidence. I mean, I thought we all knew this. Obviously, the judge's decision on this motion is no secret. Judge Summer agreed with the motion to dismiss with prejudice, and not just barely, because Baldwin's motion actually didn't ask only for the case to be dismissed, although it did ask for that, but it also asked in the alternative for the right to have the judge explain to the jury that the missing evidence could be viewed, or maybe even should be viewed, as an inference that the missing evidence would have tended to show that the bullets in question came from Seth Kinney, thereby potentially exonerating Baldwin. Of course, an out-and-out dismissal of the charges was a dream outcome for Baldwin from this nightmare scenario. Because the judge could have declared a mistrial, meaning that the prosecutor could take another run at the actor, but with a trial that included the exonerating evidence. Keep in mind, the motion was filed on July 11th. The motion was granted on the 11th. The case was dismissed on the 11th. It all happened very fast. And that's a testament to just how incredibly bad the actions of law enforcement were in the context of this missing evidence. Not disclosed, hidden, basically renamed. They did everything but destroy it. And the judge was just not having it. The dismissal of the case functionally acts as a sanction against the special prosecutor, at least in this case, showing how much was wrong with the way the bullets were handled. Another facet of this motion that we need to cover is that the defense did not just ask for dismissal of the charges and the trial. The exact title of the motion reads for dismissal and sanctions. The defense is painting a picture of intentionally hidden evidence, and the judge granted their motion, so it seems likely she may be inclined to agree with their theory. So, is a dismissed trial, no more charges, is that enough of a punishment for the prosecutor? Potentially not. It would not surprise me at all if the prosecutor gets a referral from the judge to the ethics board, because even if half of what was alleged in the motion is true, there's an argument to be made for real, measurable, personal punishment for the lawyers involved. We simply cannot have a functioning system of criminal justice if, as a people, we can't trust that law enforcement is pursuing the truth. But here they weren't. And as I said in my earlier videos, they set their sights on Baldwin, a big name, fancy actor, and they wanted to get him, even though the case made no sense as against him. Now look, I hope the prosecutor gets a fair hearing in the ethics complaint against her, and that the prosecutor of that complaint doesn't hide any evidence. It would be a real shame if the prosecutor who hid evidence had evidence against her hid that would have exonerated her. She could get a public sanction, which is like kind of embarrassing. She could get removed from the roles of prosecutors, which means she would go back to being a regular private lawyer like me. Actually, that's not that bad. But she could be disbarred, either temporarily or permanently. When it's temporary, they call it a suspension. And that sometimes there's no coming back from that. But it is clear that what she did is way, way, way outside the realm of what's okay. And that's why the judge ruled so quickly. Her defense in that trial is going to hinge on this concept: when did she know what she ended up knowing? Because if the complaining attorney, meaning the case that's made against her ethically, if that attorney cannot prove that she knew that this evidence had been mishandled by law enforcement, then ultimately it may be a case where the law enforcement personnel and not the attorneys are at fault. But according to Baldwin's motion, they've got their sights set squarely on prosecutor Morrissey. Now, the Gutierrez-Reed trial is over. Gutierrez-Reed was convicted. Her attorney has already stated that he will be moving to dismiss her case based on the decision of the Baldwin judge. This is the most obvious outcome of all time, because if the evidence is exculpatory as to Baldwin, guess who else it's exculpatory for? Gutierrez-Reed. I cannot believe that the prosecutors were involved in any of this cover-up, but it seems very clear that on some level they were, and if they weren't, multiple people at the sheriff's office were, and that is not acceptable. I am telling you right now that the conviction of Gutierrez-Reed is going to be set aside. I mean, that case is over. What are your thoughts on Baldwin's dismissed charges? I've made my opinion known that Baldwin was only being charged for show. So now I want to hear your pro se opinion. Drop down in the comments and let me know what you think. And don't forget to drop a like, drop a sub, and hit that bell notification button so you don't miss America's Attorney's next breakdown. And I will see you soon. Did I say twile? Yeah. With only 5 days left, no one can believe it.